Massachusetts. Court is now open. Please be seated.
SJC-10395, Commonwealth versus Reavis.
Morning, mister. How are you?
Lousy, but
You made it.
barely. And I would like to take this opportunity to thank the clerk for making arrangements so that I could park on the plaza here. Otherwise, I wouldn't have.
I was curious to know how you managed to get here with crutches.
This appeal started out as an appeal based on ineffective assistance of counsel. After reading the transcript and reviewing the file, the only thing we could see was the fact that the defendant, according to him, had asked the counsel to try to work out a deal so that he could plead to a lesser offense. According to the defendant, the trial counsel did not do that. The defendant knew that there was no issue of law, really, that would prevail him, and so he wanted to plead guilty. But according to his trial counsel, the district attorney, he did not permit it. The defendant believed that trial counsel did not try. So it was on that basis that the motion for a new trial was filed. And as you can see from the record, the testimony from the trial counsel and the prosecutor, there was no issue. The trial counsel tried, and he was rejected. And as I listened to the testimony at the hearing on the motion for a new trial, I could not help but think back to the days of Gary Burns and say, where were you when I needed you? Because in those days, anybody who wanted to plead to second degree, they were allowed to do so. But in this particular case, even though there was justification for a plea to second, it was refused. And of course, no one but the prosecutor has that discretion. And so we ended up with a hearing on a motion for a new trial. And the only issue, as the testimony unfolded, was whether or not there was some reason why what the defendant had sought previously, that is to plead guilty to a lesser offense, would not be appropriate in this particular case. The district attorney testified that she was indeed approached by trial counsel, and she knew trial counsel. She had worked for trial counsel when both were in the district attorney's office, but the fact is that her superiors would not permit her to engage in any plea bargaining. So we are here asking this court to consider this case under 33E. I'm not looking for anything other than 33E relief. However, 33E relief takes in a little more than maybe just reducing the verdict. It's possible that, for a couple of reasons, you may want to consider a reversal of the conviction. But in any event, whatever I'm saying here is not that I'm alleging error in and of itself justifying reversal, but if considered under 33E, then you may feel that...
Well, you exercise 33E relief if you think there was an injustice, don't you?
Well, I think so. Not only an injustice, but whether or not there was some justification for reducing it down or some justification for ordering a new trial. It has happened on more than one occasion, as we all know. In this particular case, I think I have two things I can say to you that you might consider and come up with a ruling that maybe 33E relief is available because of a couple of errors that the judge made. But more than anything else, I'm here asking you to reduce a verdict because under the circumstances, it would be the right thing to do.
Mr. Davis?
Yes.
Was there any evidence of mental illness introduced at trial or alcoholism? I know that he
yes.
had
Oh, yes.
40 ounces of beer to drink that night, but was there anything really to indicate any problem with, intent or anything, or anything to do with the instructions that I don't see any objection being raised to any of that. But I wondered what your thoughts were.
Yes, I think throughout that sort of thing was prevalent. The defendant and his wife had been together about 17 years and on and off, and they always had trouble. And the trouble, I believe the wife felt, stemmed from his drinking. And it also stemmed from the fact that he was always accusing her of infidelity. And this was going on for a long time. He had this in his mind that she was cheating. And quite often he would throw this at her. And the record reflects that maybe there was not reason to believe she was cheating, but reason to understand why he thought so. Because she was always staying out late. She was always doing things that ordinarily would not be done in a good marriage. And he was drinking and drinking. And the night that he killed her, he got off work around midnight and went to this girl, her girlfriend's house, where she always spent a lot of time, which he objected, but he went, and they were doing coke that night too. So this was the thing that they did. They did coke and they drank. And I believe from the record that that particular night, both were under the influence either of alcohol or cocaine. So this was, as I understand it, from the reading the record and from the testimony of one of the children, this was not uncommon. She, the wife, did not like his drinking so much. He did not like the fact that she was always running around. So on this particular night, the defendant got off work around midnight and he went by the wife's girlfriend's house. She was there. They were doing coke, according to him. And this came from the testimony of the defendant at the hearing on the motion for a new trial. But they were also drinking. And it started there that the defendant made accusations against her before they went home. And these accusations against the wife caused the friend to say that you ought to leave. And so they did.
And is that when the defendant said she was cheating on me and she's not going to cheat on me anymore?
He said that at the house when he stabbed her, didn't he? That was
Is
that night that
when
he
said
it.
you might never see her again?
Oh, yes, you're right. That's right. You may never see her, right. Because he thought someone was there that night, yes. That's the testimony of Karen Broder, I believe it is. Yes, yeah, you're absolutely right. Yeah.
Now, is there any suggestion that he'd been drinking at work?
No.
Okay, so he was not under the influence. When,
Well, I said no evidence that he was drinking at work.
okay, well, but
we
have to rest on evidence. But,
How long does it take you to get drunk? And they were there for a couple of hours, so I don't know.
well,
But
he
in any event,
apparently brought a 40-ounce can of beer, I guess.
Yeah.
But Was there any, were there any tests? So I guess he wasn't found until the next day, but he was taken to the hospital the next day.
Yes.
And blood alcohol done at that time, or was he in too much
There was
trouble?
no evidence of that it tested for alcohol at that time. He had tried to commit suicide, and I think that was the basis of the hospitalization, hospital treatment, yes, only that. There was nothing in the record to indicate that what level of alcohol was in his blood. Yeah.
I thought that there was evidence of Tylenol, but not alcohol in his
I'm sorry?
system. That there was, I understand that there was evidence of Tylenol, but not alcohol
Yes, and
in his
I
system.
think that's
And I don't think any testing for cocaine was done.
No.
Okay.
And I think the cocaine mostly was done by the wife.
And then, as I recall, even if there was some claim about inebriation, he did have an opportunity to select the larger knife over the smaller one that was available. I think that was in evidence, too.
I'm sorry, didn't
I think he, as I recall from the description of the evidence, that night, just before he stabbed her, he had an opportunity. He picked a larger knife over a small one.
No, I
get that right?
I didn't see that, except that I know, according to the daughter, he came into the kitchen where they were asleep on the floor, and he got a kitchen knife. That's all I saw. I don't know whether it was he had an opportunity to get a bigger knife or a smaller knife, but the point of the matter is, whatever size the knife, he stabbed her so many times that death was inevitable. Whether it was a big knife or a little one, it doesn't matter. And that's another reason why I think some relief is appropriate here. If the jury had found that it was murder in the first degree based on extreme atrocity and cruelty, I wouldn't be here. But they found death was caused by deliberate premeditation. And so with all this drinking and with all this misunderstanding about who was doing what and to whom, I think that bears on deliberate premeditation. And look at it from this point of view. We have a husband and wife. They have a 2-bedroom house. There are 4 children, 5 children there. They occupy 1 bedroom. She refuses to sleep with him that night. There are 2 boys occupying another bedroom, and the other 3 children are sleeping on the floor in the kitchen. So, not wanting to continue the argument with her husband, she leaves the bedroom, goes into the kitchen, and tells her children, "Move over. I'm going to sleep with you tonight." And the defendant is asking her to come back, and she refuses. And he goes to the kitchen and gets his knife, and he stabs her. I at least 5 or 6 times, I believe it was. There was something I thought I read somewhere, and it's been some time since I read the transcript over again. About 7 times she stabbed, but yet the jury found deliberate premeditation. They didn't find extreme atrocity and cruelty. And that's important as far as I'm concerned, because it's my understanding, even though I don't think this court has finally ruled on the issue, that if it is extreme atrocity and cruelty, then you're not going to consider relief under 33E. But be that as it may, let me...
Did Judge Brady give all of the appropriate instructions regarding alcoholism or use of alcohol or drugs or?
I think so, no. That's my recollection, and now I have to apologize because it's been quite a few months. I was supposed to have been here some months ago, and I was ready, and then I got sidetracked. And trying to catch up, I can't tell you that was so or not, but I don't recall any evidence in the charge about the alcohol part. I know that there were a couple of things the judge did that I think he should not have done. He allowed, for example, the Commonwealth to put in the evidence of the autopsy through a substitute medical examiner, and I know that this court has, under certain circumstances, said that this is okay, and I agree. But it has been my opinion over the years that a substitute witness should be allowed to testify only if the original one is not available or cannot be found. In this particular case, the medical examiner that conducted the autopsy was right across the street in Vermont. There was no evidence as to whether or not they had tried to reach her, no evidence as to whether or not she was unavailable for some other reason. All it said was that she was no longer there and that they were bringing in a substitute medical examiner to testify. No explanation as to why she wasn't there, none given.
Well, what's the prejudice here? I mean,
Well,
there's
I
no
don't know.
question that your client stabbed and killed his
The
wife.
prejudice here is that, as I recall, and it's in my brief, and I don't remember exactly where, but a couple of questions were asked about things, and the medical examiner testifying at trial could only say, well, that was what I saw in the record. That's all he could say. That's the only answer he could give to the particular question, and I apologize for not being able to tell you exactly where.
And your client was not found guilty, as you mentioned,
That's right.
of extreme atrocity and cruelty.
That's
so
correct. That's correct, yeah. Now, there was another thing, too. Trial counsel had asked the judge to conduct an individual voir dire of jurors. In particular, he wanted the judge to ask questions about domestic violence, and the judge refused. And this is domestic violence at its utmost. There was evidence that they had had physical confrontations before, but nothing anywhere near what this was. And I think this is something that built up over the years. It is not disputed that she was doing something. It is not disputed that she was always with Karen Botter. And as a matter of fact, there is one, I forget the witness now, but the defendant went to Karen Botter's house, and somebody came and knocked on the door, and he was of the opinion that this person was already there and went out the back door and came around and knocked on the front door. This is how paranoid he was about his wife and whatever it was, if anything, that she was doing. So this was something that built up over a long time. And there was some testimony about prior domestic violence. But the judge refused to ask jurors about their attitude on domestic violence. And
Well, that's not, I mean, he did ask them as a group.
yes, as a group, but the
Does
point
anybody
of the
have
matter
any
is
strong feelings against domestic violence that might impair your ability to be fair and impartial?
yes, but this is one of those that I think you have to ask independently at the sidebar.
And didn't 13 or 14 jurors came forward in response to that question? And of them, 11 or 12 were excused?
No, when they got to the sidebar, they said that. But the question was not asked out in front of everybody so they would know what was going to be asked. No, in other words, I guess what the trial counsel wanted and what I would have wanted was to put this question at the sidebar individually as a surprise, so to speak, so you might get a realistic response. But if you ask it of the entire venire and they have a chance to think about it, and when they get to the sidebar, they will have come up with the right answer. I bet $1 to a donut that those who did respond that way responded because they had a chance to think about it. And whether or not that's, I don't know, but the point of the matter is, I think this is something that should have been done individually. It is not a question that should have been put to the entire venire to give them time to think about it, but rather hit them in the teeth at the sidebar for the first time. What do you think about domestic violence? I believe that
Well, I assume that's not the question you would have had him ask. I assume you would have had to ask about their experience with domestic violence.
Yeah, it's true.
Because I'm not sure you're going to find a lot of folks who favor domestic violence.
Yeah. Well, there was finally the defendant tried to commit suicide after this too. He did not plan this, and that's what is required for deliberate premeditation. So obviously, he didn't plan this. They had had arguments before. They had had fights before, but, excuse me, never escalated to this point. Isn't there enough here for you to say that he lost it that night, that this was not a planned murder? And would you plan a murder where the weapon is in a drawer with other knives and your two children are there on the floor as you stab their mother? Is that realistic to think that that was deliberate premeditation? I don't think so.
Thank you, Mr. Davis.
Morning, Your Honors. May it please the Court. Zachary Hillman on behalf of the Commonwealth. We're asking the Court to affirm the defendant's conviction and to decline to exercise its authority to reduce the jury's verdict in this case. I'd like to just begin with some of the evidence in the case. The jury had before them slight evidence of intoxication on the defendant's behalf. There was the evidence that he had consumed a 40-ounce, not all of it, of beer that night, but the defendant's medical records showed that his blood alcohol level was 0.0.
Yeah, but that was taken how many hours after the events?
It was, I believe the testimony was about 8 or 10 hours afterwards. In any event,
Didn't the doctor say that the passage of time would have negated? I mean, that was a wash, right? I mean, the fact, the testing, the medical testing that was done of him was really
Yes.
indicative of nothing.
Yes, to some degree. But apart from that evidence, there was no evidence that the defendant consumed any cocaine that night, at least before the jury. At the motion for the new trial, the defendant did testify that he had consumed cocaine that night. But for this Court's review and for Judge Brady's review, I would suggest that evidence that was not before the jury shouldn't be considered in determining whether or not the jury's verdict should be reduced.
Was there any instruction with regard to intoxication?
There was, Your Honor. At pages 83 to 84 at volume 4 of the transcript, Judge Brady gave the intoxication instruction as it related to the defendant's state of mind. The jury was instructed on second-degree murder, and they rejected that theory, I would suggest soundly on the evidence. This is a case where, as Your Honor pointed out, the defendant told the victim's friend that she may never see her again. There was evidence that after the victim refused to go into the bedroom with the defendant went into the kitchen. In the pictures, their exhibits 14 through 17 and exhibit 19 show that there was a small knife on the counter, that the defendant bypassed that, and shows a very, very large knife with which he used to stab his wife several times. I mean, based on these facts, the jury was fully warranted in returning a verdict of guilty on first-degree murder on deliberate premeditation. I briefly want to address the substitute medical examiner issue. Unavailability is not a requirement for a substitute medical examiner to give his opinion so far as that opinion is confined by the scope of Commonwealth versus a juvenile, which this court reiterated in Nardi. Unavailability is required under the Confrontation Clause when someone who is not going to testify, their statement is admitted at trial for its substantive worth. That isn't the case when a substitute medical examiner or a chemist or an analyst testifies within the scope permissibly of Commonwealth versus a juvenile, Commonwealth versus Nardi. Here, conceitedly, the medical examiner's testimony traveled over those bounds to some degree, but this was as Justice Cordy, you noted, not only was this a case where the cause of death wasn't contested, this is a case where the defendant fully admitted that he stabbed and killed his wife. On the issue of the voir dire question, I would rest my brief apart from saying that this court's opinion in Commonwealth versus Lau controls the issue. In the end, I think this is a truly horrifying case. The evidence fully warranted the jury returning a verdict of murder in the first degree on deliberate premeditation, and I would ask this court to affirm the defendant's convictions and decline to exercise its authority to reduce the jury verdict. If there are no questions.
Yeah, I've got one on the
Yes, Your Honor.
on the voir dire.
Yes, Your Honor.
I mean, the inherent problem with regard to asking about domestic violence is that you may hear things at sidebar that they've never told anybody before. And I think there was some reference that that's what happened here, that some of these persons got quite emotional in discussing it. Is it appropriate for a judge to be asking someone to raise their hand in front of 100 people with regard to questions about domestic violence when perhaps they've told nobody about it?
Yes, it is. When the question is framed in a very general way, like Judge Brady's question was here, does anybody have such strong feelings about domestic violence that it would prohibit you from rendering a verdict in this case fairly and impartially? That is general enough where it doesn't require someone who raises their hand to be telling the rest of the venire that they have had some personal experience with domestic violence. That portion of the jurors, individual jurors' answer was properly done at sidebar because they raised their hand to a very general question posed by Judge Brady in this case. If there are no further questions, I'll rest in my brief.
Thank you, Counsel.
Thank you, Your Honors.